or our corporates. Today we are going to discuss a wonderful topic, optionally convertible debentures. Issuance of optionally convertible debentures by a private company under Companies Act 2013. It involves compliance with several provisions relating to debentures, securities, and applicable rules. So today we are going to discuss, especially focusing on what is OCD. Can a private company issue optionally convertible debentures? Can they be secured? Can they be unsecured? Applicable legal provisions and RBI compliance, if applicable. So, elaborately, we are going to discuss an optionally convertible debentures issued to the private company, even unsecured optionally convertible debentures. So, what are the optionally convertible debentures? OCDs. OCDs are hybrid instruments. They are debt instruments that provide the holder with an option to convert into equity shares. Option to convert into equity shares of the company after a specific period upon fulfillment of certain conditions. So now the question is, can a private company issue OCDs? Answer is yes. A private company can issue optionally convertible debentures under the Companies Act 2013, subject to conditions under Section 42, private placement, or Section 62, if issued to the existing shareholders, compliance with the company's prospectus and allotment of securities rules 2014. I will explain. I use the word if issued to existing shareholders. I'll explain in detail why that word is used. Foreign investment regulations if issued to non-residents. So here, can a private company issue OCDs? Yes. We are going to talk about Section 42, Section 62, Section 61, and rules. We are also talking about deposits. See, the great question is, the phrase here I used, if issued to existing shareholders. I used Section 62, refers to Section 62 of Companies Act 2013, which deals with the further issue of share capital. So, including issuance of convertible securities like optionally convertible debentures, OCDs. So, here is the reasoning. When a private company issuing optionally convertible debentures, it can do so under two main routes. One is Section 42, private placement. Another is Section 62, rights issue, preferential allotment if the existing shareholders. The private placement, Section 42, this is the most common route for issuing OCDs. It allows a company to offer optionally convertible debentures to a select group of persons, not more than 200 in a financial year, excluding QIBs and employees under ESOPs. By following specific procedures, such as issuing a private placement offer letter PAS 4, filing with ROC, etc. So this is what Section 42, private placement. The private company issues OCDs. So under Section 42. Now we'll talk about Section 62. Section 62, yes, rights issue, preferential allotment, if to existing shareholders. If the OCDs are being offered to existing shareholders. So in the context of existing shareholders, I'm talking, like promoters or current investors, Section 62(1)(c) applies. Section 62(1)(c). So this section governs the issue of shares or convertible instrument to existing shareholders and may require a special resolution of shareholders, valuation report from a registered valuer in some cases. So we are talking about OCD. Companies with preferential allotment rules, especially if not on pro rata basis. See here, you observe the distinction. Because the section 62 ensures protection of existing shareholders, rights by giving them either a right to subscribe or requiring a special resolution when their rights are being altered. If a company issues OCDs only to existing shareholders like promoter group, section 62 is instead of, or we can along with the section 42, both. In short, section 52 is about how a company can raise funds from outsiders or select investors via private placement. Section 62 is triggered when the offer is made to existing shareholders, as it impacts their ownership and rights. So the phrase, if issued to existing shareholders, is included to clarify that in such case, section 62's rules must also be complied with. So not just section 42. So here, 42 and 62, section 42 is about how the company can raise funds from outsiders or select investors via private placement. You are very clear. Section 62 is triggered when the offer is made to existing shareholders, as it impact their ownership rights. So here the phrase if issued to existing shareholders is included when we are talking about OCDs, to clarify that in such case section 62's rule must also be complied with, not just only section 42. So now we'll talk about secured versus unsecured. See, the OCDs, secured OCDs, unsecured OCDs. Secured OCDs permissible, unsecured OCDs also permissible. Secured OCDs, the conditions, secured optionally convertible debentures. The conditions must comply with Rule 18 of the Company's Share Capital and Debentures Rules 2014. Unsecured OCDs, yes, can be issued as long as the company complies with section 73. Section 73 and section 76 for acceptance of deposits, and they are not deemed as a public deposits. So unsecured deposits can be issued as long as company complies with section 73 and section 76 for acceptance of deposits, and they are not deemed as public deposits. So take care of 73 and 76. We will discuss in detail. So the important notes on unsecured OCDs. If OCDs are issued to more than 200 persons in a financial year, excluding QIDs and employees, it is treated as a public issue. So which is not allowed for private companies. Unsecured OCDs with a tenure above 12 months and not convertible may be treated as a deposits unless exempted. So we are talking about not convertible and above 12 months may be treated as deposit unless exempted. When you see Rule 2(1)(c)(9), Rule 2(1)(c)(9) of Companies Acceptance of Deposits Rules 2014, optionally convertible debentures that are convertible within 10 years are not treated as deposits. So go to Rule 2(1)(c)(9), Companies Acceptance and Deposits Rules. OCDs are convertible. OCDs that are convertible within 10 years are not treated as deposits if issued to regulated entity or under private placement. Now, the key legal provisions we'll see. Section 71 allows companies to issue debentures including convertible debentures. Coming to Rule 18 of Share Capital and Debentures Rules, applies to secured debentures. Must have a debentures trust deed, charge registered with the ROC and DRR, not required for private companies as per 2019 amendment. Section 42. Come to section 42. This is a private placement rules, maximum 200 investors per year, per security type. So section 42 private placement and 62(3) covers issue of convertible instruments under ESOP or loan conversion agreements. 62(3). Then I explained 71, Rule 18, Section 42, and again Section 62(3). And now deposit rules, Rule 21C9 and Rule 21C17. Is important for avoiding treatment of unsecured OCD as a deposits. Because someone asked me question, that is why I'm doing this video. This is a crux here. So these two rules important for avoiding treatment of unsecured OCDs as deposits. Then RBI, FDI considerations as applicable. See, if OCDs are issued to non-residents, FEMA and RBI regulations applies. So OCDs issued to a foreign investor are treated as external commercial borrowings, ECBs, or FDIs, depending on the terms and conditions like conversion option, minimum maturity period, price guidelines, and sectoral caps. So you have to take care of conversion option, minimum maturity period, pricing guidelines, and sectoral caps. So in summary, again, I'll explain like secured OCDs are permitted, unsecured OCDs also permitted. And for secured OCD Rule 18, then compliance required is charge, DTD, etc. Whereas unsecured OCDs, compliance needed is deposit rules, private placement rules, you have to take care. Then deposit treatment, secured OCDs, here it is not required. Unsecured OCDs, if convertible within 10 years, and issued on private placement, so it won't treat as a deposit. And issuable to NRIs and foreign investors, yes, subject to FEMA. And unsecured OCDs issuing to NRIs and foreign investors, yes, with care on structuring under ECBs and FDI. Take care of those ECB and FDI compliance as applicable. And first we have to check before issuing OCDs articles of association. I'll explain the checklist also. Ensure that enabling provision in the articles of association for issuance of the debentures. If not present, then alter the AOA under section 14 by passing a special resolution. Then again hold board meeting, pass a board resolution to approve the issuance of unsecured OCDs. Then decide mode, section 42. So private placement, approve draft private placement offer letter PAS4, appointment of valuer if required, regard of persons to whom OCDs will be offered, that is from PAS5. Then convene general members meeting if shareholders approval is required. Obtain shareholders approval if OCDs are convertible as section 62(3) or 62(1)(c). Section 62(3), if convertible OCDs are issued under any existing loan or arrangement, so board approval needed, only board approval needed. So section 62(1)(c), if offered to persons other than existing shareholders, then special resolution and a general member is required. And coming to valuation report, get a valuation report from a registered valuer as per the Rule 13 of Company Share Capital and Debentures Rules 2014 to determine fair value of equity shares for conversion price. So fair value of equity shares valuation is required. Fair terms of OCD issuance optional but not recommended. Fair terms of OCD issuance. Then issue private placement offer letter PAS4. Prepare PAS4 and circulate it only to the identified persons. Maximum 200 in aggregate per security type per financial year as per section 42. Then offer letter must be accompanied by an application form. MGT 14 within 30 days if special resolution is passed. Then we'll talk about the separate bank account. Open separate bank account in a scheduled bank to receive the application money. Money should be received via bank channel only, no cash. Then go for allotment. Allot optionally convertible debentures within 60 days from the date of receipt of the application money, and then file a return of allotment, that is PAS3, within 15 days from the allotment. This is the timeline. Then issuance of debenture certificates. Issue and deliver debenture certificate in a physical or demat within 6 months. Within 6 months from the date of the allotment, 6 months. So then you have to enter in a register, that is recorded details in the register of debenture holder as per section 88 and rule 4 of companies management and administration rules 2014. Then compliance with the deposit rules. Ensure OCDs are not treated as a deposit. This is very, very important. I told already rule 21C9 of companies acceptance of deposit rules, and OCD is convertible within 10 years, issued via private placement are not deposits. So summary checklist is just in a simple checklist again. I'll repeat. AOA allows debenture issue, board resolution, special resolution as applicable, private placement offer letter, that is BS4, application money received through banking channel, allotment within 60 days, and PAS3 filing within 15 days, allotment, 15 days of the allotment, PAS3, and debenture certificate issued within 6 months, and entries made in the register of debenture holder. And then here, the key cautions I will tell: OCDs must convert within 10 years to avoid classification as deposits. So since the beginning, I am focusing on deposits. I am giving you that clarity because I received a query. Because of that, I am doing this video in view of the deposits, issue of OCDs in view of the deposits. So you must convert within 10 years to avoid classification as a deposit, and take care that issue to less than 200% for a financial year, and comply with FEMA regulations if issue to non-residents, and no public advertisement is allowed for private placement. See, the entire process is governed by section 62(3). I'll tell you these sections, thorough the sections, particularly these 3 sections. Section 62 subsection 3, conversion of loan into securities when authorized by the terms of the loan agreement. Again, section 61, issue of debentures. Again, section 42, private placement. And again, rules, rule 21C, 15 of deposit rules to ensure exemption from deposit treatment, and FEMA regulations if loan was from non-residents. And again, I am telling fast you check articles of association. In the beginning, start with checking of articles of association because article should permit issue of debentures. So once the assignment comes, immediately starting, first you check articles. Issue of debentures, article should permit. Then conversion of loan into securities, that you see. If not, amend AOA by passing a special resolution. Anyway, section 14 of Companies Act 2013, you can pass special resolution. Ensure prior loan agreement has conversion clause. That you should carefully check. Conversion agreement, conversion clause in the loan agreement. Because section 62(3), conversion must be in accordance with the terms stated in the loan agreement. So for that section 62(3 you need that agreement and you need that conversion clause. So the loan agreement must include right of the lender to convert the loan into OCDs. Right of the lender to convert the loan into OCDs. Number of debentures or conversion formula or timelines in terms of the conversion and approved by the shareholders can be general or specific. So the shareholders resolution authorizing such a conversion must have been passed at the time of borrowing only or before conversion. And then after that, anyway, you will conduct the board meeting, pass a resolution to approve the conversion of loan into OCDs and approve the draft debenture terms, including optional conversion rights and fixed day allotment and authorizing filing of PAS 3. Fix the date of allotment, Then filing of MGT 14 if required. If any resolution under 179(3) or 62(3) was passed, then you file MGT 14 and MGT 14 within 30 days. Not always necessary if shareholders had already authorized in conversion either earlier. And execute supplementary agreement. This is an optional but not recommended, although not recommended. Supplementary agreement or debenture subscription agreement, we say DSA, can be entered to reflect conversion terms. Define OCD rights and conversion triggers. And then allot OCDs. The board meeting pass a resolution allotment of optionally convertible debentures, authorize issuance of debenture certificates and record allotment in register of debenture holders. Then you will file within 15 days. PAS 3 will be filed with the ROC from the date of allotment, 15 days. Attach board resolution and list of allottees and other relevant documents to PAS 3. After filing that, an issue of debentures, anyway 6 months time will be there from the date of allotment, where it comes as per section 56 and rule 6 of share capital and debentures rules 2014. Another section 56. Under this you are giving a certificate, debenture certificate, and take care of your statutory register, update register of debenture holders. Again section 88, under section 88. So now we again talked about section 88, section 56, along with the 62, 42, 71 and rules FEMA and deposit rules. See here, important compliance points to remember is here no cash flow. Since this is a conversion, there is no need to open a separate bank account under section 42. Here we are converting OCDs. Under 21C9, 21C 17 of the company's acceptance of deposit rules 2014, such OCDs will not be treated as a deposits. Here we are doing conversion of loan into conversion OCDs. Then valuation not mandatory but recommended for good governance and audit clarity, fair value. So, and again FEMA, if the loan was from non-residents, then take care of FEMA compliance, ensure RBI rules, conversion must be as per ECB or FDI norms. That we have to take care if FEMA is involved. I already told and again repeat the flow chart. Ensure AOA and loan agreement, allow conversion clause, shareholders prior approval under section 62(3), board meeting to approve conversion, file PAS 3, issue debenture certificate. And now I'm giving the answer. So the question as the conversion of loan into optionally convertible debentures OCDs by a private company is legally permissible, yes, for the OCDs to be unsecured, subject to compliance with certain conditions under Companies Act 2013 and allied rules that we have to take in. So the legality of issuing unsecured OCDs upon conversion, unsecured OCDs, your answer unsecured OCDs, no, it is allowed. But explanation is the Companies Act 2013 does not mandate all debentures to be secured. Both secured and unsecured debentures, including OCDs, can be issued. Conversion from loan, no, it is permitted. Under 62(3), section 62(3), conversion of loan into any kind of securities, including unsecured OCDs, is valid if provided in the loan agreement and approved by the shareholders. And deposit treatment, yes, deposits. We already said no. This is we can bring into exemption deposit rule 21C 17 companies acceptance of deposit rules 2014. Loans converted into equity securities are not treated as a deposit even if OCDs are unsecured. Subject to conditions that private placement, yes, OCDs, even if issued upon conversion, OCDs issued upon conversion must be allotted through private placement process, section 42. Though money was already received as a loan. And debenture trust deed, DTD or DRR. This is not required for unsecured debentures. There is no need for a debenture trust deed or debenture redemption reserve for private companies. For private companies, not required. So, take care of section 62(3). Company can convert loan into shares or securities even if the terms of conversion are approved by the shareholders at or before the time of taking up the loan. Section 71, Companies Act 2013, company may issue secured or unsecured debentures. And again, Rule 2117, companies acceptance of deposit rules 2014. Any loan from person that is converted into securities of the company pursuant to a contract are not treated as a deposit even if OCDs are unsecured. And within 10 years period that take care. So the loan agreement must have clear conversion clause. Shareholders must have approved the conversion terms under section 62(3). OCDs must be convertible within 10 years to avoid classification as a deposit, especially for unsecured OCDs. Issue must comply with section 42 private placement. OCD should not be offered to more than 200 persons in a financial year, excluding QIBs. So now final answer, yes. The purpose of video is done. Yes, unsecured OCDs can be issued upon conversion of a loan in a private company, provided all procedural and legal compliances are met. Thank you. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe our channel, RR Corporates, and the other channel, RR Legal Talks, for more financial updates and corporate law updates and public issues updates and insolvency updates. Thank you.